Good morning, everybody. Welcome back to the YouTube eDiscovery, the YouTube eDiscovery channel and hockey camp. There'll be a hockey a demonstration at the end of the thing for those who care to hang on.
I heard David's a great defenseman.
That's right. That's right. We've got a couple of diehard hockey fans here, and I would be, except I live in New Orleans. The ice situation is not too good down there. But as always, Tom O'Connor from New Orleans, Louisiana, and joined by Rachi Messing, still in Tel Aviv. Rachi?
I am.
All right. And we are very, very happy today to be joined by David Cohen, who's a partner at Reed Smith and also the chair of their records and eDiscovery group. David, thanks so much for joining us. Thanks for taking the time.
Thanks for having me today. It's an honor to be with you.
I don't know about that, but
yeah, he saes that now. Let's see in another half hour. What
hopefully in 45 minutes, it won't be a dishonor. So with that tone in mind, David, we always like to start off by saying, how exactly did you get into this wacky business? And by that, I mean, not just eDiscovery, but legal. What's your background and how did you parlay that into practicing law and then becoming an eDiscovery savant?
So my dad was a trial lawyer. And so from a very early age, I decided I wanted to be a lawyer. And it helped that I loved to argue and contentious.
Was that in Pittsburgh?
In Pittsburgh, yes.
All right.
So,
Great.
He was a graduate of Harvard Law and he was a plaintiff's side attorney, did a lot of personal injury and medical malpractice work. So somehow I ended up on the defense side more, probably because I, from my defense history in hockey. But
that's it.
Yeah. And so followed in his footsteps. There was never really any doubt in my mind that I was going to be a lawyer. And then in terms of getting into eDiscovery, I know you guys are going to find this hard to believe, but I'm old enough that my legal career predates eDiscovery.
Oh, yeah.
Shocking.
Yeah.
So
there's a few of us techno dinosaurs kicking around.
Yep. So I came out of law school in the 80s and I went to a big law firm and started practicing on big cases. And when I was the young associate, as we all know, the less favored work sort of flows downward to the youngest attorneys. And I got on some big document cases where it fell to me to manage very large populations of documents. And that was just at the forefront of actually using computers to even track and organize documents. Back then, all of the paper documents had to be coded, bibliographically coded, to type in the dates and the tos and the froms and all that. Yep. So that we could keep track of them and find out find the documents we needed to prepare for depositions and so on. So I was one of the early lawyers to get started with computerizing documents, even back when they were in hard copy form.
Was that embraced by the firm? We've had a couple of horror stories here from people our age who were kind of shunned by senior partners when they saw the keyboard come out. What was the tone around the firm then?
Well, the case it started out with one or two just mega cases, and we really didn't have any choice. And they were happy to have somebody who sort of liked technology to put on it. We actually worked with consultants to help us figure out. Back then, it was Price Waterhouse, so I learned a lot from them in terms of how to manage big projects. So it took a long time for a lot of the attorneys at my firm, and I guess in any firm back then, to completely embrace computers. But they were happy to have somebody take the document problem off their hands.
Yeah. Did you come across Jim Kane back in those days?
Absolutely did. Yes. And
Jim was an old friend of mine and a Maryland guy, of course, and we were active together in the ABA, in the law practice management section, but great guy.
Absolutely.
And David, were you like technologically inclined, or was it just you're the young associates, you ended up with it? Like, did you have a computer in the house growing up? I mean, not, growing up, no one had a computer in the 60s, 70s, but I mean, once you were actually in college, law school, were you one of those people who were kind of, kind of moving towards the computers, or one of them who was shying away from it still?
No, I did have an affinity for it. And I actually took a couple of computer classes in my college. I think at the time they were the only computer classes offered,
Right.
because it was all brand new back then. So, I always did have an affinity for it. But, looking at how far we've come, it's just shocking to look back at what we used to do. I mean, I used to have to program cards to feed into computers. And on these first document projects, we couldn't even put the databases on PC size computers. We were using mega computers with an old programming language called BASIS.
Right.
And
Wow.
it was, 5 years in before we even started moving to computers that didn't have to be hosted at a big computer center somewhere.
Right.
Did you own those, or did you have to lease time from a center someplace?
Yeah, we were using a consultant back in, and I remember when there were only a handful. I remember when there were like 4 major companies that were starting to get into discovery management. And back then, it wasn't called eDiscovery yet because it was dealing with paper documents rather than electronic documents.
Yep.
Cool. So over the course of your career, you obviously stuck with the technology side and focus. First of all, did you ever go to trial? Just wondering, because your dad was a trial attorney. Obviously, that's part of what got you in. Did you ever actually go to trial?
Many times. Back then, being a discovery lawyer was not a career. You were expected to be a litigator. And so, this was sort of my hobby. So I would say in my early years, maybe 10% or 15% of my time was spent on this. And I was just regular litigator at my firm. But then the thing is, the next big case came along with, millions of documents, and somebody said, well, how do we do this? Well, Cohen did one of these. Go back to Dave. So for most of my career, though, it was still less than 50% of my practice. And I was a third, second, and then up to first chair litigator in a lot of big litigation. It was really only about a dozen years ago when I had to completely give up my side litigation practice because eDiscovery got so big and our group got so big that I just didn't have time. And I was sorry to give it up because I really enjoy litigating. But the good news is I still get to do some of it. I'm not maybe necessarily doing the trial, but I'm still doing depositions and court arguments, focused on discovery. So that helps me scratch that litigation itch a little bit.
Yeah. Well, with the decline in cases actually going to trial, as your eDiscovery motion practice picked up a lot of that slack?
It's always been the case that in big cases, they're dominated by discovery, and most of them is probably more now than in the past, but it's always been that more cases settle before trial than actually go through trial, especially the big cases where the discovery can go on for years. So I actually feel like, I'm on one big case right now where we have a monthly conference with the discovery masters, and I'm the discovery guy, and we've got, 3 partners who are in charge of the merits of the litigation. But if you look at who's gotten the most speaking time at the monthly conferences over the last year, probably me, because there's so many discovery arguments that are going on.
Right. As contentious as trials?
Yeah, it's very contentious, but the thing I miss about trials is I used to love to cross-examine witnesses, for example. When you go into an argument, you're going to need to respond to what the other side says, but you go in with a pretty good idea of what you're going to say and where it's going.
Right.
But strategically planning a cross-examination and being prepared for whatever answer you get from the witness, I found that to be, really thrilling.
So no Perry Mason moments in discovery motions, huh?
Not really. No, I've yet to have opposing counsel admit guilt in the middle of
I did it. I give up. Have you ever had one of those go to trial?
One of the cases where big on
eDiscovery. One of the big cases. Yeah.
Yes, what often happens is there'll be like mass tort litigation, and there'll be like particular cases that are picked as test cases to go to trial just to see where things come out. I mean, ultimately, most of the big cases end up settling, but sometimes not until after you've had some mini trials, for some of the plaintiffs and that type of thing.
Right.
Very, very cool.
Cool.
So over the, you've been active within all of the various different discovery groups, eDiscovery groups, et cetera, a lot of the rule settings and what have you seen in terms of, if you look back, early 2000s through now, what are some of the biggest changes that you've seen that really impacted your daily work life?
The biggest thing has been the explosion of people involved in eDiscovery. So, when you go back, and I first created an eDiscovery group back in 2005 at my law firm. And back then, you'd see the same people at every conference, and there weren't that many of us. And the two of you guys I've known for a long time because we date back. And now, multiply that by 10 or 20. But in terms of how that's affected my daily practice, the clients used to rely on us. We had to be the experts on eDiscovery, and there was heavy reliance on outside counsel, especially those that had eDiscovery expertise and knew what they were doing. Now it's become an in-house thing. So most of our really big clients have litigation departments that include eDiscovery experts, and some of them have whole eDiscovery departments. They brought in-house what they can bring, which makes a lot of sense because that can end up, first of all, making sure that they follow consistent and repeatable practices and also cutting their costs. So it's gone from sort of being the Lone Ranger out there, figuring out everything, to working with the in-house discovery team and then the panoply of outside consultants and companies that can help us at various points in the eDiscovery process.
So
hey, you mentioned, I'm sorry,
things
Rocky,
yeah.
a quick question. You mentioned starting the group in 2005. So was that responsive to the FRCP amendments?
It wasn't specifically, it just seemed like it was growing and it was time to be not just a committee, but an actual practice group. Right. I was trying to trace back, like, when did I first remember eDiscovery being a thing? Yeah. And I found an old brochure where I went and spoke at a conference in the year 2000, and my topic was electronic discovery. So it was spelled out. It didn't say eDiscovery, it said electronic discovery. And that's the first I remember even using the terms electronic discovery. But by 2005, eDiscovery was a thing. It was a small thing. I mean, I think there were only a handful of law firms that already had formal eDiscovery practice groups at the time we started an eDiscovery practice group, but it was clearly growing. And certainly the 2005 rules amendments brought additional attention to the field.
Yeah.
Right.
Yeah.
So one of the topics that Tom and I tend to go towards is education or lack thereof when it comes to technology and eDiscovery within the practice of law. And like you said, now you go to these conferences and there's 10, 20x of what there used to be in terms of the number of people. A lot of them, I think, are more on the sales side, the technology, pure technology, as opposed to the actual legal side that have a technology bend. Have you seen anything in terms of a change, especially in the more recent years, of just the legal profession as a profession, trying to instill technology into young lawyers as opposed to trial by fire type approach and learn as you go?
Absolutely. And I think a great example of this is the fact that so many law schools have now adopted eDiscovery courses. When I went to law school and for many years thereafter, there was no such thing as an eDiscovery course. And for that matter, there weren't all that many really practical courses anyway. I did take the litigation workshop, but there weren't as many practical courses. I was an adjunct professor at Duquesne Law School for a couple of years and taught. We didn't call it eDiscovery back then. We called it pretrial practice, but that was in the 2000s after eDiscovery was a thing. So we did start to focus on it. But now so many law schools have eDiscovery courses, and it's a great way to, start getting educated. Anybody who's a litigator needs to know the basics about eDiscovery. But the other thing I'll say is that one thing that's unique about the eDiscovery industry is there are so many industry groups and there are so many conferences that there are plenty of educational opportunities. And there's even a lot of free resources available. We created an eDiscovery app that has 1 hour courses on demand. You can just pick up the free app and get an hour of CLE on, a variety of topics relating to eDiscovery. And there's many other courses out there as well, and constant conferences. So there's plenty of educational opportunities.
What's the app called? We might as well get some free advertising here.
Yeah.
We just call it the eDiscovery app, and it's very easy to find and download. Just if you have a iPhone, just go to the App Store, or if you have an Android device, go to Google Play, type in eDiscovery app, and I think it's the one and only. And the nice thing about it is it's got lots of really cool and free resources, and we don't even track, you don't even have to type in your name or anything. It takes about 30 seconds to download the eDiscovery app. So it's got the on-demand courses, it's got links to not only the federal rules of civil procedure, but the state rules in all 50 states. And there's a lot of checklists and handbooks and an eDiscovery glossary. And it's not just a product of my firm, but we've gotten lots of contributions from other law firms and from eDiscovery companies. So we have I think our list of contributors to the app is more than 50 folks in the industry, and most of them are not from my law firm. So it's become a real great community resource, and I think we're approaching 3,000 downloads now. So it's starting to really catch on.
Wow,
And
great.
did that come out from a specific need, or was that just, hey, this is something cool that we can do?
Interesting question. What I started a number of years ago was creating an eDiscovery handbook for the litigators at my firm, both to give them a useful resource and to remind them to call your good old records and eDiscovery practice group when you need us. And then we were updating that handbook annually, but with more than 1,000 litigators across the country and really across the world. We were spending a lot of money on updates, and we looked into, well, is there a way we can make this electronic and more handy for our lawyers? And it turned out that we could turn it into an app, and it would actually decrease our cost. Not only would we be able to update it constantly rather than having to wait, for once a year, but it would be less expensive, and people would now have it in their pockets, in courtrooms and depositions. We were very fortunate with timing because it came out shortly before the pandemic. Little did we know how handy that would be, because now people were at home. They didn't have their bookshelves with all their federal rules and state rules and their law firm libraries anymore. And so by having this app, we got really a lot of immediate adoption by people just now having it at their fingertips. And a lot of this stuff, also another reason why I thought it'd be great to have an app, we were constantly getting calls for particular forms. Do you have a sample legal hold notice or this or that? And, happy to, supply those, but it takes time. You don't want to charge somebody for a form. So here we could just put it on the app and, everybody would have access to it. So the biggest decision we had to make is, should we limit this to our firm like we had just had the eDiscovery handbook for our firm, or should we make it more widely available? And we said, hey, this is really useful. Let's go ahead and give it to our clients too. They'll like it and they'll think of us. And like I said, I don't want to charge them for, a legal hold form. I want them to come to me with the more important and sophisticated work. And then once we got over that hurdle, we said, well, if we're going to make it available to our clients, everyone out there is a potential client. And then, the final step was, well, what about our competitors? What about the other law firms and eDiscovery companies and so on? But we thought, hey, if we make this the best resource it can be, and we invite contributions from the whole eDiscovery community and make it available to the whole eDiscovery community, it's going to be a much more valuable resource. And even though we won't make any money on it directly, it can raise the reputation of our eDiscovery group and the firm that we're the ones that came out with the eDiscovery app. So that's how we've gone forward. We don't sell anything through it. We don't charge anything for it. And we actually meet weekly to try and constantly improve the app. So as time has gone on, we've added more and more resources to the eDiscovery app.
That's
Great.
very cool. Yeah, I'll have to check that out. I was unaware that you guys had
Yeah.
it. So that's cool.
Well,
That's
we'll definitely get the word out about that. Yeah.
Yeah.
Awesome.
So you mentioned the corporate clients bringing things in house, and having come from a corporate client where we did everything in house. I think that's definitely a trend that's picked up steam, and especially as a lot of the tools have become available, such as Microsoft 365, Google Vault, some of the other tools that are available out there to make it easier for a corporate client to actually manage a lot of the processes from a technology standpoint. But one of the things that we found, especially as I talked to my colleagues across the country, even across the world, was that yes, the technology was there, but the legal teams didn't necessarily know or understand what was now available to them. And if anything, they sometimes were getting into more trouble because they didn't have the solid processes and procedures in place to be able to actually manage it. So it became kind of this, the tools are available, they're out there, but with a little power, it can be a very dangerous thing. How much are you finding, or are you finding that you're ending up going in more so than before on a consulting role, on not the necessarily the individual cases, but from a overall corporate perspective of here's how to manage your data and manage discovery within a corporate environment?
Yeah, that's a great question. And we've definitely seen that evolution. And many of us who've been eDiscovery lawyers have then morphed into also being information governance advisors, because as you've seen, I've seen that the costs and risks of eDiscovery are directly proportional to a company's internal information governance practices. If they keep everything forever, then their eDiscovery bill is going to be way higher. The risks are going to be way higher. These days, you have to worry about data breaches, et cetera. So it's been probably 15 years now since I've also started advising companies on information governance. And in fact, that's why we call our group not just the eDiscovery group, but the records in the eDiscovery group, because a lot of our work is advising clients on information governance and litigation readiness. That's such a critical part of it. And I'm not unique in that. I think a lot of eDiscovery lawyers and practice groups now advise companies on information governance issues. But I've been doing that for, like I said, probably 15 years, and I'm very active in ARMA and just spoke at InfoGov World, and some of that whole other list of organizations that focus on information governance instead of just eDiscovery.
And are you finding that with the advent of the new corporately available tools, that it's becoming more complicated or less complicated when dealing with these clients?
New technology brings wonderful benefits, but it always brings new complications. So at the recent PREX conference, it got to debate the issue of modern attachments and whether they should be included in discovery. There are a lot of issues that we never had to deal with in the past. I think your point about it being more complicated than some people think is well taken. I saw some, all of the people that are selling software going around saying, oh, this is your easy button. You buy this software and your discovery problems are taken care of. But it's really way more complicated than that. And some corporations have learned that the hard way. And so, we recommend that you go in, if you're a corporate legal department, we'll advise, go in one step at a time. One of the first things that I recommend for in-house companies to take over is managing legal holds and tracking legal holds. And there's some great software out there to do that. Not every company should be investing in running a whole document review operation. There's ups and downs, there's complications. And so there, depending on the size of the company and how much litigation, there's a right amount of eDiscovery to take in-house, and there's still a lot of great outside resources that you can take advantage when you need them. The other thing is, it's not a one-time investment. Some companies were under the impression, okay, we'll buy this software for X dollars now, and then we're set. but you're really not doing it right unless you are keeping up and making that investment year after year, because the technology keeps improving. You need to have adequate support, which in litigation usually means 24/7 support, people who really know what they're doing, and that human capital, having people that are highly trained and retaining those people is so essential as well. So it's a lot more complicated than some companies thought going in. And as a result, we've seen some companies that have sort of cut back. They created eDiscovery groups and then they eliminated them or greatly cut them back. But I think there is a right size, and I think there are some other companies that have great internal eDiscovery groups that are very good, but they also usually rely on some outside law firms and outside consultants to help them where appropriate.
Right. How do you stay up to date? What are your
Well,
go-to resources?
As you guys know, because I see you at all the conferences, I'm going to conferences constantly. So this time of year, it's not just once a month, it's at least twice a month. So we talked about the fact that we'll all be at Relativity Fest. Before that, next week, I'm headed to the EDI conference in Miami. From there, I go to the ARMA conference in Nashville, where I'm doing 3 presentations. Then Relativity, we've got Georgetown coming up. So, really, and we were all at ILTA a little while ago. So it's really heading from one conference to another. That really helps a lot. And then also doing the professional writing. I regularly do articles and blog posts. So that keeps me up to date, and not to mention working on actual cases. Issues keep coming up and we have to research them and brief them. So that helps. But it's gotten to the point where it's a real advantage to be a full-time records and eDiscovery lawyer. We were talking before the session about the fact that, when we all started out, it was, maybe a sidelight. You were mostly a litigator. Certainly when I made partner at my law firm, eDiscovery wasn't a thing yet. So I had to make partner as a normal litigator. And then as time went on, it became a real specialty. And now it's a specialty that not just myself, but we have a team of 70 plus lawyers in our records and eDiscovery group, and it's
Wow.
our full-time thing now.
Right. So that brings up another keeping up with the times issue to me. I'm one of the participants in a monthly case law webinar that Doug Austin is the host, and Mary Mack of the EDRM, and myself and Judge Andrew Peck. Just keeping up with the case is a monumental task. I mean, Doug told us the other day when we were planning for the latest one that he reads 50, 60, sometimes 70 new cases a month. That seems to me, I've never heard of a practice area that had 70 new, constitutional law, any other practice area you can think of. There's not 70 new decisions that are meaningful every month. How do you keep up with that?
Yeah, I remember those good old days when, we'd go to the Sedona Conference and the judges panel would talk about 6 cases, and those were the 6, that came out in the last year.
Right.
Now they have to pick 6 from 60 or maybe 600.
Yeah.
So you can't keep up with every case. There's one of the eDiscovery companies does a regular alert and asks me to do an expert commentary for them, probably about once a month. And so that forces me to read and think about and comment on at least one case a month. And then preparing for these different eDiscovery conferences, we always try to bring in the latest case law. But I can't say that, I think there are other people that do this even more than I do and are, could rattle off the top of their head, what are the last 8 cases on this issue? And I'm not one of those people. I study when it's time to present on something or time to brief something.
It's funny you should say that, because I remember when I was younger, I was working with an insurance defense firm. There was always a senior partner who, if somebody said something about big rocks falling out of the sky and crushing Volkswagens, well, that reminds me of the case of, Acme versus Roadrunner in Humboldt County, California, and blah, blah, he would know the top cases in these specific areas. And it's almost impossible to do now, right?
Yeah.
It's a monumental task.
Yeah,
It's
it really is.
constant
But
challenge.
luckily, sorry, go ahead, Dave.
It's a constant challenge to keep up, but fortunately being, full-time in this area, naturally, it helps.
Right. Do you do any case law postings or discussions on the app?
We do. So there are but there's also links to some third-party sites on the
Yeah.
app that do a great job of keeping up with case law. So it's a combination. There's a whole section on case law as well as rules on the app.
Yeah, I don't get reimbursed by these people, but I follow Doug Austin with his eDiscovery today. He constantly is posting about new cases. And then Kelly Twigger's eDiscovery Assistant is a good service. That's a paid service that you can sign up, but they will send you an RSS feed. If you specify certain areas, you can get it. You can get updates from them as well. So yeah, you're right. There's a lot of, I don't know if there's a lot, but there are services.
Some solid, yeah.
Yeah, they're doing that full time, which is great.
Yeah. So Dave, I was wondering, when you look at, okay, so we talked a lot about like where we've been, what the last 20 something years have looked like from a eDiscovery perspective. Where are things headed? When you've got kind of that unique position of dealing with a lot of different clients, you're in a pretty large practice group that gets to deal with this on a daily basis. What do the next couple of years bring to us on the eDiscovery front from your perspective?
Well, that's another really good question, and I better figure out the answer to that because I'm speaking on the future of eDiscovery at an eDiscovery Summit coming up in November. I'm on a panel with Maura Grossman and Judge Xavier Rodriguez to talk about the future of eDiscovery. So if you ask me in a month, I'll have.
There you go. There you go.
But clearly, the technology is continuing to improve. Data is continuing to proliferate. What I personally would like to see is more proportionality in discovery. I think that, we come from the history of discovery being super broad and judges allowing everything. And too many judges still have that mindset that if anybody can come up with any creative argument about how there might be something somewhere, that you have to spend millions of dollars looking to turn over every stone. Whereas the technology can really help now in getting you to what you really need to find. And I just went through a big argument, one of our big cases, just to get to be allowed to use predictive coding in a case. And it shouldn't be such a big fight. It should just be automatic that you can think about it and use it. And some of the other great technologies that's coming out. So I hope there's a lot more focus on getting what's really needed and not looking. Relevance is such a broad standard because if it tends to help prove or disprove a fact, then it's relevant and discoverable if it's proportional. Well, it might not be a contested fact. If it's not contested, then let's stipulate to it and not have discovery about it. It might be the 1,000th document in the population that says exactly the same thing. You don't need the 1,000th one. You're not going to use the 1,000th one. So let's get discovery down to what is reasonable and proportional. And that would go a long way towards making the whole litigation system more speedy and inexpensive and all those things that Rule 1 of the Federal Rules of Civil Procedure says we should be doing.
Yeah. So hey, I don't want to get too deep into the weeds. I'm sorry again, Rachi, for interrupting. But you just said something that really piqued my interest. I mean, most of the decisions I've seen, and I know Judge Peck did this when he was on the bench, Judge Faciel, it's not my job to tell you, the owner or the person who has the documents, how to search. Were you faced with a situation where somebody was opposing the use of predictive coding?
Yes. The way they would characterize it is they were opposing the use of predictive coding after search terms, even the broadest search terms. And the problem was it's a case where we've already got more than 50 custodians and goes back decades. And as a practical matter, that means you can't use predictive coding without at least running some very broad search terms. And we're happy to run the broad search terms. In fact, the ones that the plaintiffs proposed. But then we want to do predictive coding afterwards. And we didn't think it would be that tough a sell, but apparently it is.
Yeah. And again, I don't want to get into the details of the case at all, but was the judge at all interested in getting into that swamp, or was any sort of a Michael Jackson going on?
We actually had a couple there's a couple coordinated cases, and in one, it's a discovery master, former judge that was appointed by the district judge, and then there's a state
okay.
court judge. And so one of the things that's tricky when you get into big cases in multiple jurisdictions is you have to convince a lot of judges, not just
Right.
one.
Right.
So, but yeah, I mean, to their credit, they certainly, allowed us to brief the issue and argue the issue, and we're waiting for a decision at this point. But, it's not the easy sell that I hoped it would be.
Yeah.
Right.
Yeah. Interesting.
And I want to push back on you a little bit on, you said in terms of the hope is that we get to a point where, the proportionality is more taken into account, and the use of the technology can be used for what it's actually good at and designed to do. But how do we get there? How do, like, that's great from a, fantasy perspective of what we all like. It'll make life easier in so many different ways for all of us. But what are some of the practical things that we as an industry can do to help move things in that direction?
Well, I think the whole education thing is really key. And I think it's also happening naturally with, new generations of judges who maybe didn't grow up in the old Wild West of discovery, and more sophistication about eDiscovery issues, continuing to make appropriate amendments to the rules of procedure and to have protocols. EDRM, you mentioned the organization EDRM, Mary Mack. EDRM is near and dear to my heart. I chair the project trustees of EDRM. And there was a committee that's been working on a privilege log protocol, and we just finalized a new version of that, which is now out for public comment. That could save a lot of money if people can streamline privilege logging and privilege challenges and so on. And there's other efforts that are out there. Another committee of EDRM right now is working to help with the appointment of special masters, knowledgeable special masters that judges can rely on, who have real eDiscovery expertise to help streamline the discovery process. So organizations like EDRM, Sedona, and some of the law schools are doing, Georgetown's got their great Advanced eDiscovery Institute, and University of Florida has got great educational programs, and others. So I think we are making progress, but it is slow progress. And one of the things that I think slows it down is that there are some financial interests in doing things the old way and the expensive way. There's a lot of companies that make a lot of money just doing document review the old-fashioned way. And while any of them, if you come to them and say, can we do predictive coding, they'll say, yeah, we can help you with that. They may not be the ones to suggest it. It could cut down how much they make on a particular matter by, half. So a lot of it is having knowledgeable people within the company and their outside counsel to suggest and manage and help get things more efficient and effective in the eDiscovery world.
So David, one thing I see with the clients who I work with, they don't tend to be big corporations like at your end of the spectrum, but I see a disconcerting lack of specificity about these issues at the meet and confer. It seems to me if you could pin some of this down at the meet and confer, you could at least put a fence around it, right? I mean, are you experiencing that? I'm astonished when I get called in, and often I get called in after the fact. And, well, did you talk about that at the meet and confer? No. Did you talk about that at the meet and confer? No. Well, what did you talk about at the meet and confer? Magistrate Judge Roby down here in our neck of the woods, down in New Orleans. I was on a panel with her once, and somebody said, well, Your Honor, what's the biggest problem with the meet and confer? She paused for a second. She said, the biggest problem with the meet and confer is that you all treat it like a drive-through daiquiri window, which of course are legal in Louisiana.
Right.
And she said, it's a meet and confer. You're supposed to meet, like get together and confer, like talk about this stuff. And, too often it's a fly-by phone call. So, I mean, do you see that, or, is there hope? Am I barking up the wrong tree, or?
Yeah, we absolutely see that. I think one of the reasons for that is that not all of the litigators that are in charge of cases are eDiscovery lawyers. And, you want to talk about what you're comfortable talking about. And so the lawyer who's the head lawyer for a particular case, both on the plaintiff side and the defense side, is not necessarily going to have a lot of eDiscovery experience or expertise, and hasn't yet gone through the process of becoming educated on the client's sources of information and their processes and so on. Because these meet and confers, these conferences happen early in the case.
They're really early,
16Bs. And, I have the same complaint you do, that the case team doesn't get our eDiscovery group involved fast enough. So sometimes we're brought in after that meet and confer has already occurred.
Yeah.
So it's viewed more as a step. Hey, we have this hurdle we've got to get over because we're forced to do this to satisfy the judge, and less viewed as an opportunity to really make progress. And I think that's changing. And I think partially because of some judges that are insisting on that changing. I mean, in my own district, the Western District of Pennsylvania, former Chief Judge Joy Conti was really good at, you go in there and you're not prepared, she's going to send you back and make you do it right. Other judges are starting to do that as well. So I think it is something that's going to change over time. But the message to get out to these litigation teams is this is important. It's a critical part of the litigation. Do your homework before you get to the meet and confer, so you can go in prepared to talk about these issues, and bring with you those who have the expertise, the eDiscovery a lawyer at your firm, or lawyers, or an outside consultant, so that you can talk intelligently about these issues early on.
Yeah, a couple of California cases I've been involved in, the California courts have been really aggressive about name an eDiscovery liaison. Doesn't have to be somebody in your firm, but have that person involved. And Judge Pexel missive, have the geeks talk to each other, bring your geek to court day. Have the liaisons talk to each other and work this stuff out. So you see that at all in courts out your way, David? I mean, are liaisons being promoted more, or?
They are, and our practice is really national. So I would say most of my cases are all over the country rather than just in Pennsylvania. But there are dangers with that as well. And I think it's really helpful. I think that there's no substitute for the attorneys getting up to speed on things. I could tell you a couple horror stories where a client brought the geek to court. There was one case, and I'll leave the judge's name out of it, but we brought the geeks to court, so to speak. And the judge said, okay, all the lawyers out of the courtroom. I'm going to put these two guys, one from each side, in a room together, and they're not coming out of there until they've negotiated A, B, C, D, and E. And you lawyers, you're prohibited from talking with them. Wow. We hadn't prepared our person with that in mind. We hadn't selected our person with that in mind. So that's one of the kinds of things. And I also find when you bring that knowledgeable person, you need to really prepare them well, because good IT people, good technology people, they're used to saying yes. Okay. Right. If you say, can you do A, B, and C? Oh, yes.
Sure.
That's their job. And so you get them in a hearing and the judge turns and says, can you do this? Oh, yes. And then we get outside, we get from the hearing, we start talking to say, okay, how are we going to go about this? I guess, oh, no problem. I've got these 3 developers on my team, and it'll only take them a couple of weeks to write a computer program that will create this database. And it sounded easy when you were in the court, you said yes to it. And now you realize that you're going to all of this effort and expense that you had no duty to do to create a computer program. And so a lot of it is preparing people and not getting them over their head. And by the way, they think it's going to take 2 weeks to develop, but when you actually do it, it's going to
be 2 months.
And be twice as expensive and so on.
Right.
Now, in the defense of liaisons everywhere, I will say that I was involved with a big case down here in New Orleans several years ago. But the person on the other side, the consultant on the other side, was Chuck Kellner, who's now with Reveal, but Chuck's been around. And the judge got so sick of the arguing between the sides, they couldn't come up with an eDiscovery exchange protocol, a document exchange protocol. She literally turned to us at a status conference once, to Chuck and I, and said, it's yours. I want you guys to come back to me in 2 weeks with a protocol. Don't talk to these guys about it. You talk to each other and then come back to me. Chuck and I did it, and she entered it as an order. It became the protocol for the exchange. So, but that just, have the right guy. That's all.
Yeah, if you have
Okay.
Tom O'Connor or Chuck Kellner, you're in good shape.
There you go.
Exactly. So unfortunately, we need to wrap things up. So I'm going to go into our rapid question phase. Dave, just handful of questions, one word or one sentence answers, just keep it nice and quick. Okay, we ready?
Ready.
So let's start with something really easy. Beach vacation, snow vacation.
It's not that easy for me. I've got a place in the mountains and I love beaches, but I'll go with the beach vacation because I'm at my mountain location frequently.
Okay. If you could give one line of advice to your younger self, what would it be?
It would be think more in terms of your career and less about the work that is right in front of you today. Because if you spend all your time just billing hours, then you're never going to hit that next level of, developing a specialty and developing your own clients and the things that really help your career in the long term. But it's really easy to get just sucked up when you have plenty of work and you're supposed to bill 2,000 hours a year. It's really easy to get just completely sucked up in that.
Favorite sport? We know hockey's there, but what's your actual favorite sport?
Well, to watch hockey and football, I actually played volleyball since college, and it's great because it's a sport that even at my advanced age, I can still play. And, I've been playing for 40 plus years now. So that's probably my favorite sport to play.
Okay, and last one before I turn it over to Tom. What was tougher? Dealing with a really, really difficult plaintiff or dealing with a really, really difficult congregant when you're president of your synagogue?
I got to tell you, being in charge of a synagogue or probably any religious institution is the hardest thing. If you can do that, then you can deal with any difficult client,
handle
any
anything,
difficult adversary.
There you go.
Yeah, that was definitely the toughest.
Yeah. Tom, it's all yours.
All right, I got one rapid fire question we ask everybody. Beatles or Stones?
Beatles.
Oh.
Sorry.
I just get used. I
I'm
should
fans
just
of both.
Yeah. Oh yeah. Of course. No. That's true. It's a tough. But you just didn't hesitate at all. You were like, man, that's it, bang.
Hey, Beatles, of course. Well, because the answer is obvious. It's like Stones, okay, we can deal with them. They're good, but the Beatles are the Beatles. Come on.
They're the Beatles, man.
Yeah.
Okay. Our last question, when we ask everybody, is if you could spend a day with anybody from our profession, living or dead, who would that person be and what would you do with them? Doesn't have to be professional. It could be skiing, could be playing hockey.
Well, there are a lot of great folks in our profession, but one name that comes to mind because he was taken from us far too young was Browning Marion. He was an eDiscovery expert. He ran various conferences. And he always brought a great sense of humor to everything. I still remember interplay between him and David Kessler, who's also got a great sense of humor in some of the conferences we attended. And unfortunately, he passed away, as I said, too young and, without a lot of advance notice. And I feel like, gee, I wish I would have gotten to know him. Even I knew him somewhat, but I wish I'd gotten to know him better. And, just he's the kind of guy that you would think you could do anything with, go out to dinner and have a fantastic conversation, go to a baseball game. So he would be somebody that I wish I could spend more time with.
Yeah, great guy. He unfortunately died right around an ILTA conference. I believe it was 8 years ago at ILTA. And at this last ILTA con, I was asked to just say a few words about him at some reception. Oh, it was the ASED reception. On Monday afternoon, and it was a real tearjerker because there was a lot of people in the room who knew him, and I started choking up, and everybody's choking up. It was like, yeah, he was a great guy. I miss him terribly. We were good friends, and he I don't know if either of you know the comedy team of Bob and Ray, but they were a New England-based comedy duo. Sort of think of two Bob Newharts talking to each other. That would be Bob, a very deadpan, very New England sense of humor. They became the voices for the Peels brothers, Bert and Harry Peels, and the Peels brothers commercials. And again, we're just, very New England. And it was when Browning and I first realized that we were each fans of Bob and Ray that we became good friends. And he would literally be reduced to tears crying at some of their bits that we had known over the years. Like you said, David, he wasn't a guy you just talk shop about. You go out to have dinner or sit around having drinks in the hotel lobby after a conference, and he was just a wonderful guy. Wonderful guy.
That he was.
Well, with that, we will wrap things up. Again, many thanks to our guest, David Cohen, partner of and chair of the Records and eDiscovery Group at Reed Smith. And we really appreciate your time and comments. This is fun. As you know, we could do this for hours. And there'd be some great content. I often think we should get 3 or 4 people in front of the camera and just turn it on and let them talk.
Just let it go first.
Just record it. Yeah. But obviously we can't. We'll look forward to seeing you, David, at some of these conferences coming up. I won't make it to EDI this year, but please give my best to everybody down there. We had Patrick on with us a few months ago, and he was, of course, great. And I always look forward to that conference. But I'll see you at Relativity Fest.
Absolutely.
And Rachi, same. Hopefully, our respective football teams will improve as
a little bit better. Do you know, just putting it out there, the Ravens have trailed out of the first 4 games for 14 seconds.
Wow.
Total, the entire season. We're 2-2, but we've only trailed for 14 seconds. That's how bad our fourth quarter collapses have been. Anyway.
Well, the Saints are sort of the Saints are the opposite. We scored for the first time in the first quarter this past week. Right. We're 1-3, and we've relied on furious fourth quarter comebacks, which have obviously not worked.
Only made it so far.
Yeah.
And there's a doink. Yeah.
Oh, please don't get me started. Sorry. All right, gentlemen, thanks so much. Yep, and to all of our listeners, thanks so much. And we'll see you next time on the eDiscovery channel.
Thanks, guys. Take care.